Good afternoon, everybody. Thank you so much for your patience. We are here today for our March Tenant Landlord webinar, an ongoing series we do once a month. Today, we're going to have a lot of information about various housing subsidy programs that are here in Minnesota. Both so we got lots of information. We're being joined by two awesome Smurls attorneys, who I'll get into more information about them in a minute. But I want to give folks an opportunity to come in and get themselves settled. So, um, but if you have questions or anything like that, feel free to drop them into the Q&A. Uh, but again, we'll get started here in just a minute. I want to make sure that everyone's kind of settled into themselves first before we get going. All right, I think it looks like we're good to go. So I'm going to go ahead and get us started. So we are joined today by Heather Mendiola and Ben Weiss. They are both attorneys at Smurls, which is the Southern Minnesota Regional Legal Services, but that is a mouthful, and so everyone just calls them Smurls. My favorite rendition of the Smurl's name, by the way, that I've ever had someone give me is s'mores. So I think you should all seriously contemplate a rebrand or at least some sort of ad campaign that involves, delicious gooey marshmallow and chocolate concoctions.
I appreciate you sharing that. Usually I see SMERLS or
Hmm.
SMURL, but I don't know if I've ever seen s'mores. I like it.
Yeah, so just that's my favorite. Someone's like, yeah, someone from S'mores is helping me, and I was like, I really
That's
wish
it.
that was true.
That's
Yep.
great.
So I've got a couple of housekeeping slides real quick, but Homeline, if you're new here, we are a nonprofit that helps with tenants across the state who have questions about what their rights are as tenants. So we've been around since 1992. We've helped over 335,000 households since then. And we do offer our services in four languages, English, Somali, Hmong, and Spanish. That's our phone number there and our various language lines. We also offer our services via email if that's what your preference is. You millennial you. I'm right there with you. Upcoming webinars, we do have one coming up in April. Um, so April 23rd, we're going to have someone from Housing Link kind of give us an overview of the current rental housing market. What are some trends that we're seeing, or I should say what they're seeing. I don't get to see them, but they're really great experts. They did this webinar for us a couple of years ago, and it was really interesting to see what just the data shows about what the housing market is like. Um, and then finally, the session is being recorded. You should have heard that when we were coming in. It should be available on Homeline's website in a couple of days once we can get it off of the cloud and sort it out. If you have questions, again, please, please, please use the Q&A function. There's a little question mark box at the bottom of your Zoom screen that then you can put the questions in there. If you try and put them in the chat, I probably won't see them because I'm going to be posting a lot of links and things, and there are a lot of links for today. There's a lot of referencing going on to various laws and statutes. So I'm going to go ahead and post those in the chat. So I probably won't see your question if you post it there. We are going to be applying for CLE credit. We should be 1.5 standard CLE credits at the end of this. You will get an email with that code once we get approved for that. So I don't have it yet. Sorry, still got to apply for it. We'll send out the code to everybody. If you don't know what a CLE credit is, count yourself lucky, but it just means that you don't have to worry about it. It's for continuing legal education stuff. All right, that is my bit. Thank you again. I'm going to turn it over to Heather. Thank you, and I will, if you got questions again, Q&A, and I'll be trying to post links in the chat for everybody.
Hey, thank you, Rachel. And Rachel, sorry, I just want to be sure, are you moving the slides?
Yep.
Or okay, Perfect. It's good afternoon, everyone. My name is Heather Mendiola. I'm a housing attorney at Smurls or S'mores, which I like. And I have the pleasure of being joined here by my colleague and coworker, Ben Weiss. So he is an attorney in our economic justice unit, so has a wealth of experience in government benefits. And so he will be kind of taking over the last bit of this presentation and talking about Minnesota housing support. He's really kind of the expert and go-to person in that area. Rachel, if you want to kind of move on to the next slide there. So we really see this presentation as really providing an overview of the most common types of affordable housing programs that you're apt to see in our state of Minnesota. And I call it an overview because, getting into the ins and outs and nuances and all the details of each of these programs will take much longer than an hour and a half. I've been doing this work for quite a while, but I even find sometimes on the daily that I have to look something up or there's a new question, new issue that pops up with one of these programs that I'm like, oh my goodness, wow, that's interesting, or that's good to know to carry in my back pocket going forward. But at least to kind of give you the basics of each program and help you learn kind of how to identify the programs and the general sort of rights and obligations under them. And I'm also calling this affordable housing programs and not subsidized housing programs, because although most of these programs we're going to cover today do involve a subsidy, so it's housing based on income, a couple of them don't. And so I just want to make sure that I don't carry on sort of that confusion that exists. Most of them are federal, you'll see, so all but one. So Ben will be covering the housing support, which is specific to Minnesota and is in, Minnesota program. All right, next slide. Okay, so the first program I'd like to talk about, it's probably one that that I think is kind of just heard about, at least more commonly than the others, at least in a colloquial sort of sense, but this is the Section 8 Housing Choice Voucher Program. So generally, here's how the program works. The tenant is known as a participant in a local public housing authority's Housing Choice Voucher Program. The housing authority issues a voucher for that participant to place that voucher in the private rental market. What happens initially is that the housing authority approves the unit on paper. So that's called an RFTA, and that's short for Request for Tenancy Approval Form. So once the housing authority has approved that unit on paper, and the housing authority looks at things as far as how much the rent is it affordable, things of that nature. And if it is, then the housing authority sets up a physical inspection of that unit, and there's certain criteria that that housing authority has to apply based on some HUD rules. And then if that inspection passes, and then once that tenant moves in, then the tenancy becomes an assisted tenancy. So meaning that the landlord and the housing authority sign a contract where the housing authority says, landlord, okay, I'm going to initially pay this amount of rent to you. Landlord, you have obligations as far as maintenance and upkeep, that kind of thing. That contract is in short called a HAP contract. This is a subsidized program, so a tenant who has the voucher does pay roughly about 30% of their household income for rent. The housing authority pays the rest. And then the housing authority's payment to the landlord is, again, kind of the theme of the HAP contract is a HAP payment. That tenant is required to recertify their eligibility, usually at least annually, with that housing authority. And the reason for that is namely that, at any given point in time, that tenant needs to be paying roughly about 30% of their household income on rent, and the housing authority pays the rest. And so just as a check, make sure that happens. Then there needs to be that recertification, like I said, usually annually. But if that tenant experiences changes related to their household income or related to their household composition, so who's in or out of their household, if they experience those changes between those years, so on an interim basis, they are required to let the housing authority know. Housing authority crunches the numbers again, lets the landlord and the tenant know if there are any changes in the rent amounts. So generally, a landlord is not allowed to demand any extra money from the tenant than what the housing authority has approved for rent. There's a HUD rule that says generally the initial lease must be at least a year. Notably, with a Section 8 housing choice voucher tenancy, the landlord is under no requirement to continue to renew that lease. And then if there is going to be a lease termination, that landlord is not required under the Section 8 program to give any sort of pre-eviction, pre-court sort of, appeal or grievance procedure. All right, next slide. So the main legal authorities with the Section 8 housing choice voucher are the HUD rules, and so they are laid out in a particular part of the HUD regulations that I have on the slide there. Additionally, every housing authority has discretion to and how they apply certain HUD rules, or they can have their own rules as long as HUD says that they're reasonable and okay. And so those are laid out in a policy, and then generally you can find that policy on the housing authority's website. Of course, the lease between the landlord and the tenant, right, is applicable. And then as well as that HAP contract. All right, moving on. So some common issues that we see sometimes with Section 8 housing choice voucher tenancies is that if the unit fails that initial inspection, so that initial move out inspection, so the housing authority is not allowed to, under the HUD rules, to pay that landlord rent and to start the tenancy as an assisted tenancy until the unit passes that initial inspection. Now, what if it's become, that a unit is assisted, right? And that initial inspection passed, but there's a follow-up inspection at a certain point. And so if that fails the follow-up inspection, usually that housing authority has to stop HAP payments. And so we see language like abate HAP to the landlord. Usually that landlord has roughly about 60 days or so to correct the deficiencies in the inspection for the housing authority to restart the payments. If those deficiencies are not corrected within that 60-day timeline or so, usually what happens is that housing authority has to cancel that HAP contract with the landlord. The tenancy is no longer assisted tenancy, and then that tenant is given a new voucher that they can find a new place to use, or excuse me, a new place to rent with their voucher. So for increases in rent, so that HAP contract between the housing authority and the landlord, as well as the HUD rules, require that the landlord give both the housing authority and the tenant a 60-day notice before increasing the rent. And so sometimes we see issues where the landlord has given a 60-day notice to the tenant, but hasn't to the housing authority. And so really for that increase to be enforceable, the housing authority has to take a look at it at least 60 days ahead of time and has to review it and approve it. So with lease terminations, and so if a landlord is electing to try to terminate the lease in the middle of the lease term, the landlord is limited to do that in only circumstances in which it can prove a serious or repeated lease violation. So something like non-payment of rent, tenant caused damage, criminal activity, things like that. One catastrophic consequence for Section 8 voucher holders when it comes to an eviction filing in court is if that tenant loses the eviction, meaning a judge decides that the landlord should be given back the property and the sheriff can come and move that tenant out. That means that the tenant is evicted, and that means that under the HUD rules, the housing authority has to terminate that voucher. And so that's a really important thing for a voucher holder to know if they are responding to an eviction of that potential consequence. Additionally, what can come up sometimes is if there are issues between, not between the landlord and the tenant necessarily, but between the tenant or the participant and the housing authority. So if there are issues maybe regarding tenant not completing recertification paperwork, or maybe kind of not being up to speed on telling the housing authority, hey, my income has changed, or I worked this job, this or that, that can result in that Section 8 participant receiving a notice of termination of the voucher from the housing authority. But that participant does have a right to an appeal process before the housing authority can really stop those payments to the landlord. Voucher expiration. So I have seen this from time to time, and this is really tough. So when you have a voucher and you're given a period of time to look for a place to rent with your voucher, you're not given an infinite amount of time. It's finite. And so the housing authority has to give an initial 60 days. You can request longer, especially if there's a disability-related reason to need more time to find a place. But at a certain point, that shopping time will expire. Under the HUD rules, there's no express right to kind of appeal or try to get an additional extension. And so that can be really tricky for someone who's up against the end of their shopping time as far as to extend it. And it could result in expiration of that voucher, meaning that the voucher's gone. And then another issue that can come up sometimes is that if the tenant's household income is becomes so high that that tenant's portion of rent covers the entire amount of the rent, so that the HAP payment that the housing authority would make to the landlord is zero. So if that tenant's household income remains that high for a period of 180 consecutive days, so roughly 6 months or so, then what happens is that the housing authority has to terminate that voucher because kind of it's looked at as well that the tenant does have enough household income to cover the rent. And so the voucher then will go to another family who needs it in order to afford housing. All right, moving on to the next slide. So with evictions, so one thing to look for if you're a Section 8 voucher holder responding to an eviction, if the eviction is non-payment, is the rent owed? If the rent is owed, can the tenant catch up on the rent, maybe with support of financial assistance and some court costs within the period allowed under the law to stay put? I'll talk about the CARES Act a little bit towards the end of my portion of the presentation. If it's a breach, so just remember that if the tenant does lose an eviction, they lose their voucher. So with a breach eviction, kind of just looking at is the breach material. Does that landlord have evidence to prove a breach? Holdover. So if that landlord is saying that, well, I ended the lease, I gave a notice to the tenant, lease is over, that's a holdover eviction. Is the notice good under the lease? Also, has the landlord given that notice to Section 8? So they're required to give it to Section 8. So I've had some times where I've seen issues where the landlord has not, and then we've been able to argue that that's not a proper holdover eviction because the notice is no good. With settlement agreements, I really recommend to anybody who has a Section 8 voucher, if they are settling an eviction in court with the landlord, to really make clear to the judge in court that I'm settling this eviction. I'm not asking the court to make any decisions about what happened. I'm not admitting that I've done anything wrong, that I've broken any term of the lease. And that can serve as sort of a protection, if you will, for decreasing the chance of any sort of termination of the voucher related to that eviction. All right, moving on to the next slide. All right, so I think it's a good idea to kind of give some sort of tips on kind of how to tell if you're dealing with one particular affordable housing program over another. I kind of give these tips to my newer staff attorneys as they are learning kind of the basics of these programs. And so what I've learned over the years, if I have a client, for instance, who's saying things to me like, I gave such and such paper to my worker said, and the worker's at a housing authority. If my client follows up and then says, also, I live at a house. Right. So these other type of programs I'm going to be talking about, usually they don't live at a house, they would live at some sort of large complex. And then when we get into things like, oh, there's a HAP contract, there's this what's called Section 8 tenancy addendum, the RFTA form, also big indicators here we're dealing with in HCV, moving papers, inspections. Those are all sort of indicators of a housing choice voucher. All right, moving on.
I actually we've got a couple of really like Section 8 specific or housing choice
Oh,
voucher specific questions
yeah.
coming through.
Okay.
And normally I do wait until
Sure.
the end on these, but I thought since we're in this part of the
Yeah,
world,
absolutely. And it's a
so
little hard, my eyes. I'm kind of not a
yeah,
good
right.
multitasker. So thank you, Rachel, if you're able to kind of keep track of those and just interrupt. Yeah, so what
That
are
is why I
those?
am here. That is my whole purpose
Thank
here.
you.
All right, so we just a couple of quick questions. So Alexandra is wondering, when a client reports a change, does the yearly date change or stay the same?
The yearly date. So does that mean with respect to an annual recertification effective date, or I'm not
I
sure
Yeah, Alexander, if you
the yearly
can,
date
or
change?
do you mean a lease, the initial like year lease, or if you can give some more explanation, that would be lovely. Thank you.
Yeah.
And Melissa is similarly questioning, with interim recertification, is there a time frame for the rent to be recalculated?
Yeah, and so this answer can, there's a little nuance in this depending on what
Hmm.
type of affordable housing program you're looking at. But generally, once either the housing authority or the landlord is aware of a change in income, they're supposed to be recalculating that within a reasonable amount of time. And so HUD really says no more than 30 days. With housing choice vouchers, the effective date of any sort of change in income depends on what the housing authority's policy is about the effective date. So a lot of times what I see with housing authorities is that they'll have a 1 month sort of waiting period before the effective date of the change, whether it's an increase or decrease. And I think that's usually to give them the time administratively to sort of process and crunch the numbers, get all the verifications. Um, However, the tenant does need to make sure that they are reporting that change promptly, right? So with Section 8 vouchers, the Housing Authority's policy lays out what the reporting timeline is. So there are some housing authorities that have a real quick expectation as far as reporting period if they give, 10 working days, so 2 weeks. I've seen other housing authorities that give you 30 days. So it's really important to kind of know what that timeline is. And so if that kind of answers with the project-based subsidies that I'll get into in a little bit, they're a little more specific. So they say, for instance, if it's a income decrease, the landlord has to get on that right away and apply the decrease the first of that next month, assuming that that tenant, reported it promptly. And then if it's a increase, as long as that tenant reported it promptly, then that project-based landlord has to give at least 30 days notice of an increase. So that's where it quite kind of depends on the program. If it's a housing authority or housing choice voucher, it depends on that housing authority's policies. So this question in particular is good because it illustrates kind of how you need to know what affordable housing program you're working with, right?
Hmm.
And then if you're working with a Section 8 voucher, then you really need to know the policy of that housing authority that you're working with.
Layers upon layers, for sure.
Yeah, so the quintessential attorney response, right? It depends.
Yep.
It
That's going
depends.
to
Yeah.
be happening a lot, I'm sure, today. Uh,
Yes, probably. Yes.
and Alexander was quick and said that, yes, the certification date, does that change or does that stay the same?
Yeah, so that's a good question. I'm trying to think with respect to Section 8 housing choice vouchers. I don't think I've ever seen an annual recertification date change.
No,
I cannot think off the top of my head of any reason for why that would ever change.
because that
I
usually is
have seen,
connected with the
oh,
lease
sorry.
term, right?
Yeah, and usually it's connected with when that tenant initially became a voucher holder, right? When they went from applicant, because they're considered, this is really nerdy, but they're considered an applicant when they're initially get their moving papers, their very first set of moving papers, very first voucher looking for their very first unit. And then at that period of time, and then when they lease up and all the paperwork's done, that's kind of roughly about the time of when their like annual recertification date or month would be. I have seen, so for the project-based subsidies, I have seen sometimes landlords move that annual recertification month around a little bit. So HUD says that they have to recertify at least on an annual basis typically. They can do it more often. So I have seen, especially if you're dealing with large like subsidized housing providers that have project-based subsidies, sometimes they want to do like bulk sort of annual recertifications, right? Because it's administratively sort of like easier. Some want to kind of split it up, right? And have them throughout the course of the year. So I have sometimes seen, I've had clients who are like, oh, I just had my annual recertification, but then I got a note I'm going to have my recertification in the next few months. Reach out to the landlord. Oh, yeah, we're trying to kind of like move around just like for efficiency's sake. So I've seen that, but I
Hmm.
don't think I've seen it with respect to a Section 8 housing choice voucher. And I kind of not aware why a housing authority would ever really do that. But
You might be looking for logic where no logic exists.
yeah, yeah, but there is at least the 12-month
Hmm.
requirement
Yeah.
generally. Yeah.
So awesome question. All right.
Okay.
Last question related to Section 8, and I think this is a very
Yeah.
common one. So,
Okay.
so
Okay.
Section
Hopefully I
8,
can answer it then.
I almost certainly, if Section 8
Okay.
renter inspection doesn't pass, and the
Yeah.
HAP suspends their portion of the rent, does the Section 8
Yes.
renter become responsible for the full amount of rent?
Yeah, so that is indeed what happens. So there is a part of the HAP contract, and I think the HUD regs say this too, is that if the HAP contract terminates, the lease automatically terminates, right? But here's the problem. If that tenant stays put after that HAP contract terminates, the housing authority cannot be paying the landlord anymore, but that tenant continues to stay where they are, right, and gets the benefit of that unit. It's
Hmm.
going to be at a certain point that landlord will likely file an eviction for non-payment of rent.
Sure.
And that tenant's going to have a hard time being able to stay in that unit and not argue that they're not ultimately responsible for the entire portion, right?
Hmm.
And so that tenant really is in a tough spot if that's what happens. And I think that I would be hard pressed to think of any tenant in that circumstance who would say, actually, I don't want my voucher anymore. I want to continue to stay in this unit that presumably has some repair problems, right? Because
Hmm.
the inspection didn't pass. So yes, I would say generally that tenant then is in that situation if they continue to stay put, that they are kind of taking over responsibility for the whole rent.
Hmm.
Now, Heather, if they send out an abatement notice that gives the landlord 60 days to fix it, then
So
the tenant does not become
right, that
responsible at that point, right?
so there is a distinction, yeah.
Yeah.
But the question was if that HAP contract terminates, right? So the
No,
HAP
it was.
contract terminates at, oh, sorry.
Oh, sorry. I didn't mean that. The question was
No.
if they didn't like they just failed their inspection is like the
Oh,
common
okay, so
term, right?
in the
Yeah.
abatement period, yeah. So in that abatement period, before the HAP contract has actually terminated, right? This kind of like period of time where landlord, you've got like 60 days to like, get stuff done. Otherwise, we're going to pull the plug in the contract. Within that period of time, the tenant is not responsible for the Section 8's portion. So essentially, that landlord is just at a loss of that income from Section 8. And so sometimes we do see that where landlords don't appreciate that or know that or understand that and then might file an eviction for Section 8's portion. And then we resolve it and say, no, 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 like here are the rules, here are the regs. Tenant's
Mhm.
not responsible for that. So it's really important to know whenever I have a case like that come into me to know where are we at with the abatement, right? Like,
Yeah.
and is this abatement? Is this just suspension of the HAP payments? Or now are we at the point where there's no more contract between the housing authority and tenant? So it's really critical to know where in that timeline things are at. And thank you, Ben, for speaking up. And sorry that I misunderstood the question initially.
That was on me. So thank you. That also explains the second half of the question as well as what
Okay.
happens if the landlord does come back into appliance, within those 60 days,
Yep.
but they're kind of like,
Yeah.
they're not getting that portion of the money back. So,
Right.
which is
Right.
an incentive to keep the place in reasonable repair for sure.
Yes, and that HAP contract, I mean, the landlord's is signing that they're committing, to certain things in exchange for that HAP money, right? And one of the big ones is maintaining the unit.
Yep.
And so that's the landlord's representing to the housing authority and getting that money that they are maintaining the unit, right? And if Section 8 finds that indeed they're not maintaining the unit, then they have no right to those payments.
Okay. Thank you so much for all of that. That's a lot. I know. Okay,
Yeah.
that was it for the Section 8 specific questions. I'll let you
Okay,
move on with our
perfect.
with our process.
Yeah, so I think with that, we can move on. I think we're on to the next program. All right, so public housing. So in general, in this type of program, the tenant rents from the local housing authority, and I think people kind of generally know about this program at least a little bit. So we have a housing authority who owns and manages the property. So we're not dealing with a private landlord here. This is what's generally known as kind of like a project-based subsidy, if you will, in that this is not affordable housing sort of subsidy or program that the tenant can take with them like a voucher is, right? And so if we do have a tenant that moves out of their public housing unit, that means that they no longer have the benefit of that public housing. And I think it's important to note that we really are seeing less and less public housing as it's strictly defined under the federal regs. That can be a whole other presentation itself about, well, why and what's going on and why are we? To tell you the truth, like in the last few years I've been doing this, I haven't been dealing with as much public housing as I used to about 10 years ago. And we are seeing these conversions, which I'll touch on in a little bit later from housing authorities working with and operating these public housing programs to these kind of a little bit different programs where different rules apply. But the important thing to note is that the physical sort of structure would stay the same with those conversions. So I just felt like I needed to share that when I'm talking about public housing, because again, we're seeing less and less of that. But if we are dealing with public housing, the lease may not be terminated or non-renewed except for a serious or repeated material violation, other good cause. So just something to know. This is a subsidy program. So the tenant, again, will pay roughly about 30% of their household income. They will pay it directly to the housing authority. The tenant recertifies again with the housing authority. There is that sort of interim recertification that happens if there are changes in between that year. And the nice thing about public housing is that there is a pre-eviction grievance procedure with the housing authority before the housing authority can take steps to end the lease. All right, so moving on to more about public housing. So the main legal authorities that we're working with, if indeed we are working with public housing, is a couple parts of the HUD regulations that I have listed there. Of course, the lease should say public housing lease on it. HUD has issued a public housing occupancy guidebook. From time to time, HUD will update their guidebooks. So, but that can be found, at least for now, on HUD's website. And then just as a housing authority has a Section 8 policy, the housing authority also has a public housing policy. So these are usually called admissions and occupancy policies, or ACOPs, should also be in the housing authority's website. There's also a federal statute on public housing. So you see that there in the slide. All right, moving on. So some common things we see with public housing. So one thing that's good to know is that a public housing tenant does have the choice about kind of how they want their rent to be calculated. So they can have it calculated based roughly on the 30% of their income, which is my experience tenants go for, or they can opt to pay the housing authority's flat rent, whatever that is. And they've got a choice at the time that they are admitted and move in and at their annual recertification on which one. So we've talked about the good cause requirement. There's a mandatory terminations for methamphetamine. I've never seen that. If the tenant does become over income for public housing and they're over income for 24 consecutive months, so a 2-year period, then there will be a vacate a few months down the line. And then again, what I said before is that if a tenant does move from public housing, so whether it's by choice or there is an eviction, they cannot take that public housing with them. All right, moving on. All right, so lease termination. So this is really unique to public housing. So again, if public housing does apply, and that is what we're working with, there's a pre-eviction filing grievance procedure that the public housing authority has to apply. There's a limited sort of exception in which the housing authority can say, well, I'm bypassing that and I'm going to file an eviction right in court. It's in very, very limited circumstances where there's they can really show proof of some drug activity or like violent criminal activity. But otherwise, if the housing authority can't show that, then they have to give the tenant a grievance procedure. What's nice about that grievance procedure is it's 2 bites at the apple for the tenant to sort of try to resolve that lease termination before an eviction in court. And so the first opportunity is this informal settlement agreement. So I see that it's kind of like an informal sort of sit down with the housing authority of let's discuss what's going on and let's try to like resolve the issues. And oftentimes that can work. And so if it's resolved then and there, great, it's over. If there is no resolution, then that tenant has the right to the next bite at the apple, which is a formal grievance hearing. So it's a little more formal. There's a hearing officer. It's more kind of stepped up than a sit down, but it's not as kind of formal, you know, it's not in court yet. If that hearing officer rules in favor of the tenant, the great thing for that tenant is that lease termination over, housing authority has to drop it, cannot proceed with filing an eviction or anything. Also nice for the tenant, though, is that even if the tenant loses that formal grievance hearing, if that housing authority still wants to proceed with the lease termination, that housing authority has to file an eviction in court. And then that housing authority has to start over. So all the court rules apply with respect to evidence and testimony and things of that nature. And so if that tenant can, you know, win that eviction in court, the tenant gets to stay. If the tenant loses the eviction in court, of course, that they do have to move. All right, next slide. So some things with evictions once there is an eviction filing with public housing. So some things to think about with non-payment is, was that lease termination given to that public housing tenant with the right to the grievance procedures? Is the rent owed? I'll talk about the CARES Act in a little bit. I'll talk about this new HUD 30-day notice in a little bit. If there is a breach of lease, again, was that lease termination notice given with the right to the grievance procedures if they apply? What is the housing authority's evidence? So this has been in the works for a bit. There's now a state statute in Minnesota giving a right to counsel for court-appointed counsel for any public housing tenant who is facing a breach of lease. So that is really, really good to know. Here in St. Paul, Smurls, so myself and my team, we are the court-appointed counsel for any public housing tenant who is responding to a breach of lease eviction. That's good to know. And then for settlement agreement. So again, just with this type of affordable housing, if this public housing tenant, if they do move out, they can't take the affordable housing with them. So if they are responding to an eviction and maybe they want to talk about a settlement agreement, especially like a breach, looking at maybe working out what we call kind of last chance agreements with the tenant. So working out some sort of terms in which the tenancy can continue. If that tenant is looking at moving out, I always kind of advise any tenant, especially tenants in public housing or any affordable housing program, to look at trying to get the landlord to agree to mark that eviction confidential right away, or at least get it expunged in a relatively short period, and then asking for a neutral reference. All right, moving on. So tips on how to tell whether you're working with public housing or not. So a big tip is that, does that public housing authority own and manage the property? But even more than that, look at the lease. If it's a public housing program, that very top part of the lease literally should say public housing lease. If you're still missing that, but if you see somewhere in the lease where it references 966.4, that is an important part of the public housing HUD regulations. And so that should be another clue that what you're dealing with is likely public housing. All right, moving on. Oh, Rachel, I'm so sorry. I know you're talking, but
I
I
did
can't
that.
hear you. Okay.
Yeah,
I've
I
done
did
that before
that.
too.
I doubled up my my mutes. So for Andrea is wondering, for public housing, does the tenant go through the grievance procedure before an eviction gets filed? Is that an option after the eviction is filed? Could they start, doing a grievance procedure after the fact for whatever reason?
No, so the grievance procedure is designed to be a pre-eviction filing grievance procedure. It's really kind of viewed as sort of this kind of alternative dispute resolution kind of thing, where the tenant, because they live in public housing, has the benefit of some enhanced due process protections, right? And those kick in before the housing authority can file that eviction in court, right? So the idea is that by the time the housing authority has filed that eviction in court, that tenant has been given those enhanced due process protections, and still, in spite of that, it hasn't been worked out, right? But then what's nice is that for all the lawyers kind of on here is that the eviction is considered a de novo proceeding, meaning that even if that tenant, wasn't able to resolve things, at the informal sit down, and then even if that tenant, lost the formal grievance hearing and the hearing officer said, no, I agree with the housing authority, you should be evicted. All of that is irrelevant by the time the housing authority files in court. So the housing authority has to prove their case to a judge, right? And if the housing authority can't prove that, that tenant gets to stay. And then backing up a little bit, if the hearing officer, the formal hearing officer, decides in favor of the tenant, it's over. The lease termination cannot proceed anymore. It stops. Housing authority cannot say, oh, I don't know, hearing officer, I don't really agree with you, I'm going to file an eviction in court. No. So yeah, grievance procedure is pre-eviction filing grievance procedure, before, not after. The remedy for if a public housing tenant loses that eviction, their mechanism to appeal is the same as anyone who is wanting to appeal losing an eviction, right? Landlord or tenant, and that's the Court of Appeals.
Right. Thank you so much.
Yeah. All right. Project-based assistance in general. So project-based subsidies. There are lots of different kinds of project-based subsidies. Lots of different kinds. There's like Section 202, Section 811, Section 236, Section blah, 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 blah. I could go on and on. What I'm going to do instead of getting into all those different like variances is to talk about project-based assistance really in general, because for the most part, most of these rules that I'm talking about apply to all of them. So usually what we see is that the tenant rents from a company. It's usually a nonprofit. So for instance, Common Bonds has a lot of project-based subsidies and project-based units and buildings. The subsidy, again, project-based, right? So tied to the unit. So this is affordable housing, like public housing, where the tenant cannot take with them if they move away from the complex. Again, we're often dealing with, we're dealing with companies, so we're dealing with medium to large multifamily properties. So we aren't dealing with a house. The tenant is entitled to these good cause protections, which is nice. So we can't have a project-based subsidy that just says, oh, just lease terminated or not renewing. Again, it is a subsidy, so that tenant pays roughly about 30% of their household income. They pay it to the landlord. There's no housing authority involved here whatsoever. The tenant does recertify. The tenant recertifies with the landlord, so with a common bond, for example. There is that interim recertification process that happens if it needs to. There is a pre-eviction grievance procedure here always. So unlike public housing, where I said there's kind of a limited exception where the housing authority can, if they believe that they can bypass the grievance procedure, there's no bypass here. However, one bite at the apple if you have this type of housing, meaning one opportunity you have, and it really is kind of a formal sit down with the property to try to resolve the lease termination. Even if it's non-payment of rent, the tenant's entitled to that. If there's no resolution, then the landlord may file an eviction in court, but again, they're starting over, have to prove their case to a judge. All right, next slide. So the primary applicable legal authorities here for the most part for project-based subsidies are a HUD model lease. So you should see a lease and it should say HUD all over it, just say model lease. Oftentimes in the lower right-hand corner of the pages of the lease, it'll even say something like HB:4350.3 or HUD dash and then some numbers. So that's often an indicator that you're dealing with this type of project-based housing. All right, next. So some common issues we see with this type of housing program. So recertifications and terminations of assistance. The landlord is required here to do a recertification, usually annually. The landlord is expected and required under the HUD rules to give the tenant a series of notices and reminders that, hey, the recertification is coming up. These are the kinds of things, the kinds of papers that we're going to need to continue to recertify you and continue your subsidy, and then give a tenant an opportunity to request a meeting if there are kind of bumps along the road. Notably, if something happens with that recertification where that tenant does not get in all that paperwork, at some point, what is going to happen is that rent is going to convert from that subsidized amount. So whatever portion, of or whatever amount of rent the tenant was told to pay, that's a portion of their income, 30%. At a certain point, they're no longer going to be responsible for that. They're going to be told they're responsible for this like market rate rent amount, so the whole amount of rent. And then that subsidy would be terminated. The lease would not be terminated, but the subsidy would. However, once that recertification is finalized, that subsidy can be reinstated and should be reinstated. Now, the landlord is on the hook. So if the landlord doesn't follow its requirements with respect to giving out the right notices and following the timelines and the deadlines, then HUD says, okay, landlord, you cannot terminate that subsidy, right? And so I sometimes see issues where that has happened, and then I represent the tenant and go back and advocate for my tenant and say, no, the steps weren't followed, so go back and reinstate the subsidy, and I've been successful. And then this kind of is a little bit what I talked about in response to the question about timings of things related to recertification. So with the project-based assistance, the landlord must give that tenant at least 30 days notice of an increase in their rent when that tenant does report promptly. And then the decreases then have to be applied the first of that next month that that tenant reports the change. All right, next. So some things that can kind of come up in eviction. So sometimes I've seen issues where landlords will go to the tenant and say, you know, tenant, I believe that you have violated your lease. XYZ has happened. I believe I have good evidence. So, you know, if I were to file an eviction in court, you would lose. So let's just cut to the chase. It's just better for everyone. Sign this piece of paper saying that you're going to move out. The landlord does that, the tenant signs. There was no sort of sit down, the pre-grievance, you know, meeting that the tenant's entitled to. None of that happened. And then landlord files an eviction in court. And then at a certain point, tenant, maybe they come to my office or another legal aid, or they learn more about their rights, right? That they were entitled to like this pre-grievance like appeal process before going to court. And they're like, wait a minute, that's what I want to do. That's what I want to do. I don't like, if I had a choice to like challenge this, like I don't, you know, I can't move. And there was a Court of Appeals case in the 80s about this very issue. And the court said, well, you know, landlord, you still have to follow these pre-eviction procedures, right? And so even if you believe that you have enough evidence, you still have to give a notice to the tenant, right? And then you still have to give the tenant an opportunity to meet with you. And if at the end, the result of that, if the parties still want to sign like a move-out agreement, that's fine. But if you bypass all that and file an eviction, you can't do that. So the courts have recognized that these pre-eviction sort of notice procedures and protections and appeals are that important that those need to be followed before a case can be heard in housing court. All right, so if this is a non-payment of rent eviction, so some things we look at was the lease termination notice for non-payment 30 days. I'll talk about the CARES Act 30-day notice requirement in a bit. Is there rental? Were there recertification issues, right? So is this a non-payment or rent eviction where the rent converted to market rate rent? And maybe the rent isn't properly at market rate rent because maybe the steps weren't done to terminate the subsidy and convert it to market rate rent. So those are some things that we look at. If it's a breach of lease eviction, what's the breach, right? Is it something super, super minor that's just kind of silly? Is it something where, you know, it's a really material, it's a really good reason? What's the evidence? Settlement agreement. And so for tenants who are settling, if they're in a situation where like, no, like I don't want to move out, I can't move out. I don't really believe that I violated my lease. If it's a breach, look at maybe working out some sort of agreement with the landlord to stay. And then especially again, if the tenant is looking at moving out, always encourage them to try to get the eviction more confidential or at least expunged in a relatively short period, and then asking for a neutral reference. All right, woo, that's a lot. Moving on. All right. So some tips on how to tell if you're dealing with some sort of project-based assistance. Again, you're usually dealing with some sort of medium to large multifamily complex, certainly not a house. The rent's based on income. There's no public housing authority involved whatsoever. So that should be an indicator to you. You're probably dealing with some project-based assistance here. And again, if you're looking at a lease that says HUD all over it, HUD model lease, you know, you're seeing references to HB 4350.3. You see this HUD form 50059, not to get too far in the weeds, but that relates to the recertifications that the landlord has to do. And so that's specific really to this project-based assistance. All right, moving on. Okay, so now we're on to a different sort of affordable housing program. This is still a subsidy. This is called a project-based voucher. And this can be a bit confusing, and especially for attorneys who are just kind of starting out in this practice, PBVs can really be tricky to figure out what's going on. So this isn't generally how it works. So the tenant is a participant in the Housing Authority's project-based voucher program. So similar to them being a participant in an HCV program. And I really see this program as kind of a blend or a hybrid between like a project-based subsidy and a Section 8 housing choice voucher that's movable. There is the inspection requirement, there's the HAP contract, again, there's the subsidy part of it, there's the HAP payment, the recertifications with the housing authority. So all of that's just as it would be with a Section 8 housing choice voucher. The initial lease must be a year. So here's the difference. And so once the tenant has completed the initial 12 months, and they have to complete that initial 12 months in the unit, then they can go to the housing authority and say, hey, here's what I would like to do. I would like to move out of here and I would like to request a housing choice voucher, right? So that then I can take that and I can take it in the private rental market and I can rent from another landlord. What's really critical here is a couple things. The tenant needs to satisfy their initial 12 months lease with the landlord, okay? And then before they take action on their plan, they need to go to the housing authority and say what they want to do. Here's what I want to do. I want to move out of here. My initial 12 months are up. And then I want my Section 8 housing choice voucher. If they don't do that and they move out and then go to the housing authority and say, oh, okay, well, I want my Section 8 housing choice voucher, housing authority is probably going to say, okay, you're not eligible for it because you're supposed to talk to us in advance. And then I think we might have had a question about this kind of in advance. And so the way that this kind of works is that, you know, if that project-based voucher participant goes to the housing authority and says, here's my plan, right? The housing authority is expected to either go ahead and issue that Section 8 housing choice voucher, or if they're you know, if they're in a position where maybe their wait list is closed or they're not able to issue one at that time to that participant, then what they need to do is put that participant at the very top of the list so that the next time that they're able to go ahead and issue more Section 8 housing choice vouchers, they can issue one to that participant. All right, one important thing to know here is with project-based vouchers, if there's an issue between the landlord and the tenant, as far as if the landlord's wanting to terminate the lease or they're going to file an eviction, there is no pre-eviction grievance procedure here like there is with some of the other programs I talked about. All right, Rachel, you can continue. All right, so the legal authorities here, so there's the HUD regulations, and so for project-based vouchers, you look at Part 983. Interestingly, and this can kind of be confusing, most of the Section 8 housing choice voucher regulations also apply here, most of them. You have the lease, of course. The housing authority will also have a PBV policy on their website. Usually what I find is that the PBV policy is embedded somewhere in the Section 8 HCV policy, so you can probably find it in a little section kind of toward the end there. All right, moving on. All right, so some common issues with project-based vouchers. So usually it's the 12-month rule that comes up, right? Is that, and that tenant has to complete that initial 12 months before they can get that Section 8 voucher. And then, so sometimes project-based voucher participants can have some sort of issues with the housing authority, and that the housing authority might say, oh, you know, you didn't, you know, follow this sort of reporting rule or something like that. So we're going to terminate your project-based voucher. And so with that, though, the project-based voucher participant, like the Section 8 housing voucher participant, does have a right to appeal process before their voucher can be ended. All right, next slide. All right, so when we think of evictions for project-based vouchers, so with non-payment, again, is that rent owed? I'll talk about the CARES Act notice in a little bit. For a breach, is it material? What is the landlord's evidence? Again, for settlement agreements, just as I stressed for Section 8 housing choice voucher holders, I stress the same here, is that the tenant really wants to make it clear to the court if they're settling with the landlord that they're not asking the court to make any decision about what happened. They are also making clear to the court that they're not making any admissions that they did anything wrong or breached any violation of the lease. And again, that can kind of help protect them if, you know, from any sort of voucher termination related to this eviction. And then the other thing to think about, if this is an eviction and that project-based voucher tenant is still within their 12 months, they need to figure something out so that they can at least stay that 12 months there so that they'll be eligible for the housing choice voucher. And if they're working out some sort of agreement like that, make sure to be in touch with the housing authority in advance to say, hey, here's my plan. Again, I want to stay here my 12 months and then go ahead and get my housing choice voucher. Right, next slide. All right, so how to tell if you're dealing with a project-based voucher. And again, this can be tricky because it's kind of a blend here of two different types of programs. So rent, of course, would be based on income. There's recertification with the housing authority. Again, you have the lease between the tenant and the landlord. But you hear about this 12-month requirement. And a lot of my clients, like it's ingrained in them in the beginning, fortunately, by the housing authority. They know they have to stay put for 12 months and they have no right to have a Section 8 housing choice voucher and move before then. So a lot of times my clients will kind of tip me off. If it's a building that has supportive services, so a lot of time these project-based voucher properties and units have some services tied to them, and probably a nonprofit. So in St. Paul, I just know from experience that some properties have project-based voucher units are like Jackson Street Village, Liberty Plaza, Rivertown Commons. And then of course, ask the housing authority, right? Like the housing authority should know what type of voucher that they're giving to a participant. All right, moving on. So, rad conversion. So I don't want to get too deep into the weeds of this, but if you've heard of this, this is really where you're dealing with a situation where you have a housing authority that has a public housing program that has taken steps to convert their public housing program through this RAD program to convert to a different type of affordable housing program. Either I see like to a project-based voucher, right? Or to project-based rental assistance. So I don't want to get too far into it. This can be like pretty confusing. If you or yourself are kind of mixed up on this or have some questions or something, certainly you can, reach out to your local legal aid. I do want to make note that St. Paul PHA, I think 2019, 2020-ish, did convert most of their public housing units to RAD PBRA. So functionally, the physical units, everything's all the same. It's just that the rules are a little bit different. And so for that, you would go to my slides for the project-based assistance, and those rules would generally apply. But not to be more confusing, but I just didn't want to be remiss in just kind of explaining that, we're seeing less and less of public housing, and we're seeing these RAD conversions. All right, moving on. All right, so this I think is the last program I'm going to be talking about. And so that's Section 42 low-income housing tax credit. So in general, so one thing to really kind of stress to folks is that this is not a subsidized program. All right, so if a tenant is living in a Section 42, has a Section 42 tenancy, if they have no other affordable housing program involved, they're not paying a percentage of their own income toward rent. All right. And this is not a HUD program. So all the other programs, that I talked about are a HUD program. This is a Department of Treasury program, not HUD. So in general, the federal government here allocates tax credits, and state housing agencies will distribute the credits, monitor compliance, and then report to the IRS. So the deal is that properties get these tax credits, and then in return, they are required to keep the rent at certain rent limits that are percentage of below market rate rent. And so usually what we see what's called set aside. So that at least either 20% of the units have to be set at rents that are that are based on 50% or lower of area median income, or set 40% of the units at 60 based upon 60% or less of the area median income. It can be kind of confusing, but the main thing to point out is that for a Section 42 tenancy, the rent is based on area median income. It's not based on a particular tenant's income, and the particular set aside, that would be something that if you're needing to find that out, you can talk to, I have it kind of the last bullet on this slide. Minnesota Housing is our state finance agency. So they're the primary kind of agency in charge of these tax credits and monitoring. And there are a few cities and counties I have listed there that are also in charge. But again, this is not rent that's set at a particular tenant's income. This is a program designed to encourage private investment in affordable housing. To each their own about if this is really helping tackle an affordable housing crisis or not, or making it worse or having no benefit. I am neutral on that. One critical thing to know is that With this Section 42 tax credit program, landlords cannot say, I don't take Section 8 vouchers. I'm not going to accept any tenant who wants to move in with a Section 8 housing choice voucher. So that is good to know. It's also good to know because you could have a tenant who has a Section 8 housing choice voucher, right? And then happens to live in a Section 42 building. You will see that sometimes. So then it can be confusing. So you think, well, but wait, I live in this building at Section 42, but the rent that I pay is based on my income. It's not because of the Section 42, it's because the tenant has that housing choice voucher. All right, moving on to the next slide. So the main legal authorities here, there's a couple of federal statutes. And then again, there is a tax credit compliance monitoring manual. So if you're dealing with the state of Minnesota and they are in charge of compliance monitoring, they have their tax credit manual on their website. If you're dealing with a sub-allocator, so one of the counties or cities on my previous slide, they each have their own manual. It's very similar to the states, and you can find it on that website there. All right, moving on. All right, so some common issues. So one thing to know about this Section 42 tenancy, and you might think, well, what benefit is there because the rent's, not subsidized? Well, there is a good cause protection. So the tenancy cannot be terminated or cannot be non-renewed unless there is good cause. So tenants have the benefit of that good cause in this type of program. And then most of the compliance manuals, at least that I've seen, require the good cause be listed in any lease termination notice or any non-renewal notice, and certainly an eviction complaint. There is the limitation on rent increases in that they may only be increased every 12 months. Also, of course, the rent amount is subject to the applicable rent limit, as I talked about a bit ago. All right, moving on. So with evictions, we look at, is the rent amount within the rent limit? So we'd want to find that out if that's a concern. A rent increase, so how many rent increases have there been, if any, in the last year? Holdover eviction, there's no such thing. Again, there's the good cause protection, and that's the same as for breach. Okay, moving on. All right, so how to tell? If there's a Section 42 addendum, so every Section 42 tenancy, there's the requirement of, it's called a lease rider. So it's a piece of paper, says, it's supposed to inform the tenant, hey, you live in a Section 42 unit, there's good cause protection, some other things. So if you see that, that's a big indicator. And if you don't know about that yet, if the rent isn't based on income, but it seems lower than market rate rent, like it just feels like the rent should really be higher here, that can also be an indicator. All right, moving on. So I'm going to touch on a couple more things, and then I want to make space for Ben to talk about housing support. So just in general, the Violence Against Women Act, that was first enacted, I think, back in the 90s. It was reauthorized a couple of years ago. It does apply to all the housing programs I've covered, including Section 42. So generally, under this law, you cannot be denied admission or assistance or evicted or terminated from any of these programs because of domestic violence or dating violence, sexual assault, or stalking. HUD has a VAWA landing page that you can go to for more information on that. All right. Okay, the CARES Act. So briefly touch on, because I want to make space for Ben. This is something that, we're going to see. So this has been enacted since kind of when COVID really kind of started coming up, March of 2020. Initially, there was a 120-day eviction moratorium. This CARES Act applies to all the housing that I've covered in this presentation so far. The 120-day moratorium passed, that's no longer in effect. But what we have left here is this 30-day notice that a landlord, that the CARES Act says the landlord would give if the tenant is behind on rent. There's been some litigation involved in other states about whether the 30-day notice number one is still in effect, whether it didn't go away with the moratorium, or whether the landlord has to wait that 30-day period for the rent to come before they can file an eviction, or whether they can, give the notice, but then file the eviction at some point within the 30 days. Notably, there's been no appellate decision in our state, so maybe that's to come, maybe it's not, I don't know. There has been some appellate decisions across the country. Some have been in favor of landlords on this issue. Most have been in favor of tenants. There was an Iowa Supreme Court decision, though, in effect that basically said that 30-day notice isn't a thing anymore. The National Housing Law Project has some really good materials on this. Again, I don't want to get into the nuts and bolts of the CARES Act and debate that right now in this presentation, but just wanted to kind of bring it up. And then the next thing. Okay, I think this is my last part. So HUD recently issued this 30-day notice rule. And it applies in cases of non-payment of rent. And so not to get too far in the weeds, it is worthy of kind of looking at the National Housing Law Project stuff on this for more insight, but and all the different types of housing that it applies to and what it doesn't apply to. But in essence, for certain types of HUD programs here, HUD says, okay, landlord, you are required to give the 30-day notice, all right, for non-payment of rent, and then sit and wait that 30-day period, allow that tenant to cure by paying rent before you can file an eviction. So, this has only been in effect since mid-January. So we haven't seen any sort of litigation on this yet. We had one case where this was relevant, but we did settle with the landlord, and then our client was able to pay rent and then not have to pay the court costs. But will definitely be interesting to see this playing out in the courts here because it is relatively new. All right, I think, is that the end of me? It is. So Ben, finally, what we've all been waiting for, knock us out of the park with housing support.
All right, and this I'm only covering one program, so I should be able to get through this in time to answer questions. So housing support is it, and I see that there are some questions building up. So housing support is a different enough beast from everything that Heather's talked about that at Smurls we deal with it in a different unit. Most fundamentally, it is a state public assistance program. So it's completely state funded. There's no HUD or federal government involvement at all. And it operates like other state welfare programs such as General Assistance, Minnesota Supplemental Assistance, in that it is administered by counties under the supervision of the Minnesota Department of Human Services. And housing support is kind of a program that started out as one thing and has morphed into an umbrella covering a whole lot of different disparate things. So it used to be known as group residential housing, and people at counties or advocates or others in the biz still tend to refer to it as GRH. And as the name suggests, originally what it was a pot of state money that was used to fund residencies in group homes. And it was basically kind of a nursing home model where people had to turn over the vast majority of their income to the group home that they were staying in. They got a small personal needs allowance monthly, as residents of nursing homes do, and then the group home took care of, all of their basic needs. But because the law had some wiggle room in it, it has expanded considerably. And so now, in addition to traditional group homes, what we're seeing a lot of is situations where GRH is being used to pay a nonprofit organization to provide a rent subsidy and to provide supportive services. And some of these are in site-based settings, similar to some of the project-based programs that Heather talked about. But we're also seeing it where the person actually rents from a private landlord, but GRH is providing a rent subsidy, and then there's a nonprofit providing services. It is by statute limited to individuals with disabilities. So there's always a nonprofit organization involved, and there are kind of three flavors of nonprofits that participate in GRH. One is, this is more the traditional group homes, but nonprofits that are licensed through either the Minnesota Department of Health or the Minnesota Department of Human Services. And there's a whole lot of different flavors of license that might apply. The second is, so this is the one place where the federal government comes into it, is HUD-funded supportive housing for the long-term homeless. So there are, HUD has a funding stream for people that are coming out of homelessness and that have been homeless for either 12 consecutive months or for, I forget what the exact figure is, but it's a certain number of months over a 3-year period. And people have to go through what's called a coordinated entry or coordinated assessment process. And I'm seeing a message in the webinar chat saying, are there no slides for this portion? I am looking at the slide that I prepared. Are attendees not seeing the slide that says housing support in general?
I see it. I think it's up.
Yeah, I am sorry if it, yeah, everything that we've got here indicates that it's going, so it may be an issue on your end. I'm sorry. Um, I will, yeah. This will be available, these slides will be available on the website. If for whatever reason this is not viewable now, we promise you'll be able to see it in a couple days at the
Yeah,
latest.
because it looks like it's coming from two different people. There's one in the Q&A and one in the chat.
Oh,
Or nope, I'm sorry. The one in the Q&A says I can see the slide. So
oh, okay.
okay. Yeah, so it looks like maybe it's just on the end of the person who posted in the chat. So all right. So anyway, that HUD-funded supportive housing for the long-term homeless can also receive GRH. In order to get into that type of housing, somebody has to go through a process called coordinated assessment or coordinated entry that runs a common waiting list for those programs. Then the third category, and I think this is the one we're seeing the most of, is what's called a supportive housing establishment with a habitability inspection and an individual lease agreement. And this can be either site-based or scattered site in private market housing. And supportive housing is basically just defined as it's not time limited. It provides or coordinates services necessary for a resident to maintain housing stability and is not licensed as an assisted living facility. So this is, a pretty big category. All right, so there's been a recent change in how a tenant's portion of rent is calculated. So as I said, for sort of the traditional group home setting and still for some other settings under this program, the tenant has to turn over all of their income except for this $128 a month personal needs allowance. But if somebody is in that supportive housing where there is an inspection and an individual lease with a landlord, whether that's the nonprofit of a site-based provider or a private market landlord, then effective last October 1st of 24, the rent is now 30% of income. And then the way that the rest of it works is that the county pays the nonprofit and the nonprofit pays the landlord. And most people in GRH housing are single adults, but occasionally you do get families with kids, and there is a special rule for people who are receiving both GRH and MFIP, Minnesota Family Investment Program, which is the cash assistance program for families with kids that people generally think of as welfare. And that is that if there's a household on MFIP that's in supportive housing, then their income for purposes of calculating their rent is considered to be only $250 a month. That's the only portion that counts. And so if it's a traditional setting, then their rent's going to be $250 less the personal needs allowance. If they're in one of these scattered site supportive housing, then I believe their rent's going to be 30% of $250. Next slide, please. Okay, so the legal authorities for housing support, this gets to be a lot of fun in our unit. So the basic law is under Minnesota Statutes, Chapter 256I, which gets my vote for the most opaque, confusingly organized chapter in all of Minnesota statutes. It's very difficult to follow. In addition to being difficult to follow, it is also pretty it's also incomplete on a lot of points. Because this is a state welfare program, there's supposed to be there are constitutionally required protections in terms of notices that have to be given to terminate assistance, in terms of appeal rights. And if you look in Chapter 256I, it's not there. So the Minnesota Department of Human Services has administratively written a lot of these rules into its combined manual. And the combined manual is not technically law, but for these issues with GRH, it's what there is. Now, other things that apply are by statute, every housing support provider, every one of these nonprofits, has to have an executed housing support agreement with the county. And so that's something that you have to look at in terms of looking at what rules apply. And under the law, that housing support agreement must include a list of circumstances that could result in a resident's eviction. So that's a step that we have to take, is to try to get a hold of that agreement and see if whatever they want to evict the person for is on this particular, is on the list submitted by this nonprofit for this, with this housing support agreement. And then you also have to look up the laws that are applicable to the type of license that the nonprofit holds. So with these state health and state human services licensed facilities, some don't have any real additional protections whatsoever, but some have a lot. So you have to figure out exactly what you're dealing with and then look up the law that applies to that type of license. And then there is a, if it's that HUD supported, that HUD funded supportive housing for the long-term homeless, then there is a part of the Code of Federal Regulations that applies to that. Next slide. Okay, so in terms of figuring out the common issues with housing support, the issue we run into is there's a lot of different players, and we kind of have to pin down where, with which player the sticking point is happening. So if it's an issue between the tenant and the private landlord that they're renting from with housing support, there aren't any overarching protections for housing support participants from eviction beyond what normally appears in state law. A landlord can evict on any, on any state law basis, whether it be non-payment, holdover, breach. But what landlords and landlord attorneys and advocates should keep in mind is there is going to be a nonprofit in the picture, and they're there for a reason. And that should be the first place that you, as a landlord, go in terms of trying to resolve the problem. If it's a non-payment, then the provider should be involved in pulling together resources, whether it's county emergency assistance or outside funding, to resolve that non-payment issue. And in Ramsey County, actually, if somebody who's receiving housing support applies for emergency assistance, they are told, first you need to go to your housing support provider, to that nonprofit service provider, and have them see if they can come up with resources to resolve the problem before coming to us. They should also intervene if it's some sort of a breach issue. Much of the time, this is for people who are are pretty disabled. They may be mentally ill. They may be coming out of homelessness. There may be a lot of issues there. And these issues are what the provider is being paid to deal with. So if there's some sort of issue that might constitute a breach, the first thing you should do is go to that provider and say, hey, here's what's going on. If the eviction goes through, that provider should stick with the tenant and help them find another landlord to rent to them with the continued services. So because this is a state welfare program administered by the county, sometimes we do run into issues where the issue is with the county. And if there's a problem with the county, then there's a right to appeal to the Minnesota Department of Human Services. It's an administrative appeal process. So like with Section 8 vouchers, recipients of GRH have to recertify annually, and that recertification is processed by the county. And the nonprofit should take care of meeting with the tenant, getting everything signed, getting all the verifications together, getting it all in. But what sometimes happens is then everything goes into the county and the county financial workers are backed up. And so the recertification doesn't get processed in time. And so the payment to the landlord stops coming. And that's a situation where legal aid might be able to help to push it through. If the county wants to terminate the housing support for some reason, they are required to give a 10-day notice of termination. And if the recipient appeals within the 10 days, then the county is required to keep the housing support going until the appeal is resolved. So the third party that there might be a sticking point with is the nonprofit service provider. And there is also, if they're trying to terminate services or back out, there is also a right of appeal to DHS. And this is where the questions to ask are they following all the requirements of their license status and of their housing support agreement before either evicting somebody from a site-based property or withdrawing their services if this is a scattered site situation? And if the provider is not doing their job, they're not stepping in, they're not helping the client address their barriers or their issues, then it is worth complaining to the county. And there's in Ramsey County, there's a particular planner who oversees housing support who those complaints go to. Next slide. And this should be the last slide for me. So how to tell if you're dealing with housing support. It can sometimes be challenging because, again, they come in both, it comes in both scattered site and site-based flavors. So if it's scattered site, it's housing support if the tenant's paying 30% of their income and the rest is being paid by a county human services department. If there's a nonprofit social service provider that's involved in matching the tenant with the landlord and represents to, maybe if you're the landlord, that they'll continue providing services, you're probably dealing with housing support. And if the nonprofit is asking the landlord to complete forms for a county, such as a shelter form or a lease, again, you're probably dealing with this program. If it's site-based, it can look a lot like the project-based programs that Heather's talking about. It's probably a complex that's owned and operated by a nonprofit, but a portion of the rent comes from there's a portion of the rent coming from the county human services department, and that's the tell. So I see a couple of relevant questions. Does the agency need to be a nonprofit agency in order to have a housing support agreement with the county? I believe the answer to that is yes. Let's see.
Yeah, we've got a whole bunch of questions here
Yeah,
as well. Yeah.
yeah, I'm just picking out the housing support ones.
Oh, sure.
Can you tell if a client is receiving housing support by looking at the lease? Not necessarily. It's probably going to look like just a regular private market lease, and that is again an indication that you're not dealing with any of the HUD stuff that Heather was talking about, and that you're probably dealing with housing support is. And somebody asked, is this similar to ICS housing with a lease? And I don't know what ICS is.
I'm not certain I know that acronym either.
All right, and I think the rest of these are probably more in Heather's ballpark.
Yeah, so lots of questions. We had we only have just over 10 minutes left, which is great, or just under 10 minutes, which is fine. I will get through as much as possible, but I also want to say thanks all to joining us today. Um, I think one of the big overarching general questions that I would like everyone to have answered before you have to go is how do tenants who may be participating in these programs, if they have complaints with, whatever, whether it's the recertification process or, maybe how things are going, is there a way that they should complain or, basically push back against potential problems with the program?
I think the overarching
Yeah.
answer to that is to Sorry, Heather. I think
Oh, go ahead.
I think the overarching answer to that is to call your local legal aid. So, Smurls is the legal aid for Ramsey, Washington, Dakota, Scott, and Carver counties, as well as the southern third of the state. There is a different legal aid that covers Hennepin and Anoka. Go ahead, Heather. Sorry.
Yeah, no, that's what I was going to say, especially too, if I saw one of the questions about recertifications, right? And maybe the landlord not doing them or being behind on them or doing them incorrectly. That's absolutely a legal issue because the landlords are obligated in getting the benefit of the HUD assistance. They're obligated to do that timely. And so, yes, we see those issues a lot. So don't hesitate to reach out to us. And I would say the sooner rather than later. It can be harder to sort of unpack and it can be harder to resolve the longer kind of it festers, right? So like I've seen recertification issues where maybe the rent was, or excuse me, the subsidy was terminated back 2 years ago. And not only is the landlord not, really terminated the subsidy properly, but then the landlord takes no action in addition to
Yeah.
that. So then lets the rent continue to accumulate at market rate. And then it's thousands and thousands of dollars. And then at a certain point files an eviction, right? And then if we get involved at that point, happy to do it, right? And we've had cases where we've been able to like get the subsidy reinstated retro to 2 years before. But it's harder to do that, right? And it takes more time to do that, and it's a lot to like figure out. So if you're having issues now, like please contact us sooner rather than later. And those are absolutely things that we want to do. And that's just one of the that's a critical case for us, right? Because then
Yeah.
if you're having recertification issues, like that's jeopardizing your housing, right? Like you're losing your subsidy at some point and you could be at risk of even like the landlord filing an eviction, a wrongful eviction. So
Yeah.
absolutely consider us because these are legal issues for sure.
Yeah.
It's not so much as like a customer service issue, right? Although you could say like it is, right? But it's a legal issue.
hmm So I dropped the phone number for legal aid in there. Legal aid got
Perfect.
a statewide phone number for everybody, which
Yes.
was awesome. Thank you. So basically, if you call that 877 number, I think you just push in your zip code and it will direct you to whether you get a
Yes.
Smurls or a Mid-Minnesota Legal Aid or a Justice North. So for folks on
Yes.
the phone or who folks are listening in, you don't have to figure out who is my legal aid group. They have figured that out for you. So thank you. And then ICS is Integrated Community Services through the Caddy Waiver system. That's another
Yeah.
program that we see a lot
Yeah.
of, but I don't know how that integrates or not, doesn't. I think it's separate, but you're the experts here.
Yeah, that's more covered. That ICS is covered not by really either of our units, but anything under the Caddy waiver kind of goes through the Minnesota Disability Law Center, and I don't know how that interacts with housing support.
Cool. All
Mm.
right. If there's any other questions that you want to see in here, that you want to answer, you have a drive to answer, go for it. Otherwise, I'm just going to start kind of going through the specific ones and try to grab the ones that were pre-submitted ahead of time that are, really specifically relevant to today.
Oh. I see. I have a real passion for VAWA and the protections under VAWA. So this caught my eye. Does a VAWA procedure or form have to be used at the previous unit in order to enforce its protection from being denied at a new unit due to domestic violence? Absolutely not. No. And I've helped clients with this. So if there's a domestic violence issue that happened at a previous unit and for whatever reason, that results in a denial of a new unit under a VAWA covered program, there's no requirement that you had to have asserted VAWA initially at the prior unit to get protections to be admitted to a new unit. But that's a great question.
Yep. Uh, Someone was asking about USDA RD. That's another sort of subsidy rural
Yes,
development, which
yes.
is, I know we didn't touch on it today because there are so many. But
Yeah, and thank you. Yeah, I did want to mention that quickly, Rachel. So thank you. So
mhm,
yeah, the USDA, U.S. Department of Agriculture, it has affordable housing program known as rural development. That is not a program. So all the rules and procedures and obligate, all the stuff that I talked about today and that Ben talked about today would be different and would not be applicable to the USDA RD program. And so I don't see as much of that here being in the metro, but my colleagues kind of in Southern Minnesota see it. And I know that there's a particular handbook or guidebook that the USDA put out specific to that program. So you would want to look at that. And then again, if you are having a legal issue related to that, definitely call that legal aid number.
Cool. All right. So then the other one was we had a very specific question. I honestly don't know if this is something that's too deep into the weeds. Is there an explanation of how most high-tech buildings with tenants incomes of 30% or lower of the area median income, and yet providers are able to charge these tenants if they have incomes of 60% of the area median
Yeah,
income?
so that might be, so that's related to the set aside. And so
Mhm.
what it would be good to know what set aside applies to that building, right? Whether it's the 20 at 50, 20% of the units at 50% or less of area median income, or it's 40% of the, at least 40% of the units at 60% or less of AMI. So it might be building that has that 20 or that 40-60 AMI. But the way to go about getting that answer would be to reach out to Minnesota Housing, right? Or if this is a city or county in which the sub-allocator applies, right? And that's listed on my slides, to reach out to that particular sub-allocator, because that's how you would find out for sure what set aside the landlord is required to apply. And then whether or not, if they're not complying with that set aside, that's a compliance problem. And then that would be good for either Minnesota Housing or that sub-allocator to know. And then this is really nerdy, but if there's not compliance with that tax credit program, what would happen is that an IRS form, I think it's 8823, would be filled out and given to the IRS, and then that property's at risk of losing their tax credits. So yeah, you'd have to know the particular set aside and then reach out to the monitoring agency for that.
Yeah. So we are past time, and I want to be respectful of that. If you're able to stand for a couple minutes, we can go through, but also just want to say thank you so much for, all of this really in-depth information. It's complicated programs and systems, so really appreciate
Yeah,
you.
yeah.
Um,
No problem. I apologize. I do have to sign off. I've got some childcare responsibilities.
Absolutely.
But thank you, Rachel. Thank you, Ben, and thank you everyone who attended. And I hope this was informative.
Well,
Yeah, and I
yeah.
can probably feel the rest of what I'm seeing in the Q&A. I think
Okay.
a lot of it's so.
Okay.
Yep.
Okay,
Perfect.
yeah,
Thank you
Okay.
so
Thank you
much.
both. I'll sign
Bye,
off
Heather.
here.
all right,
Thank you.
thank you.
All right. Bye.
All right.
Okay, so
Okay.
just looking at these, so yeah, there's a few questions specific
Mm-hmm.
to an issue going on with Common Bond, and I would recommend that you call that legal aid phone number. I don't know what
Yep.
county you're in, so I don't know if you'd be with us or
Mm-hmm.
with one of the other legal aids. Um,
Yeah.
with
And I'm gonna jump in there quick as well. If it's a repair issue and things as well, not necessarily specific to your subsidy, you can also call Homeline, and we can talk through that. A lot of intersection between what just any other tenant is able to do and what a tenant in subsidized housing is able to do is often the same thing. So,
Right, and the same with the person who asked about attorneys we can get in touch with for problems in our apartment with management.
mhm.
Um, there's a question, what if the landlord is putting the rent higher than the Section 8 payment allowance? So, um, yeah, there's a Heather didn't really touch on this. Um, well, she did. I guess I can see that question being two ways, and one of them Heather touched on, and the other she didn't. And one is that if the issue is that the landlord is trying to make the tenant pay than what the more than their 30% portion, that is an illegal side payment. And that's something that's potentially a criminal issue for the landlord. Um, if the issue is that the landlord is kind of making it impossible for people to get Section 8 because they're putting the rent above what the Section 8 does have a rent cap based on um, my understanding is that it's kind of flexible is that it's not an absolute cap, but it's kind of a function of the individual household's family size and income. And yeah, we do see situations where a landlord is charging too much. is charging more than what the Section 8 will pay. I believe that that is actually a situation that's an exception to the illegal side payment thing, that the tenant
Mhm.
can move into the unit and Section 8 will pay up to their maximum and the tenant will have to pay 30% of the rent plus the difference.
Yeah.
I think in general, will recommend that you look for a different unit.
Yeah.
Somebody asked if we live in a low-income building for disabled and elderly, what are our rights? Basically, what we need to find out is what type of low-income building for disabled and elderly, because it could be any of the things that we've talked about. It could be public housing, it could be a project-based voucher, it could be housing support. And so the first thing we need to do is figure out, figure
Mhm.
out what law applies to that particular building. Um,
Okay.
Does Section 8 fall under public assistance related to fair housing? This is
Oh, what a
very
great
complicated.
question. That's why I didn't answer it just as a type answer because it's not a yes or no question or answer.
Um, yeah, oops, I gotta divert a call.
Oh, sorry.
Um,
I can
um,
take this one real quick if you want
yeah,
to deal with
yeah.
that.
I
So,
just had to send it to voicemail, but you can go
oh,
ahead.
okay, sure. So under Minnesota law, Section 8 does not qualify as public assistance for discrimination protections. There was a big Minnesota Supreme Court case about 15 years ago now, that basically said through some complicated reasoning that because of how Section 8 and housing choice vouchers were designed and set up, that they don't actually qualify as public assistance that's protected. Which I'm going to say this because I'm allowed to do this. There is some work going on in general at both the federal and state level to try and get source of income like Section 8 vouchers and things like that as a protected class so that landlords can't deny someone solely based on the potential tenant receiving a Section 8 voucher. So,
Okay. Yeah, somebody asked about a place called Dover Hills, and I don't know anything about that. I don't know if that's in our service area. I think that, again, we kind of have to
mm.
know what sort of a setting it is to know what laws apply.
Yeah. And a lot of these are very specific. And it is, if you've got specific questions about your specific situation, it's honestly best that you call or email an attorney. Smurls or your legal aid group is going to be a really, really great resource to ask and figure out with your specific issues. This is really not the appropriate place to be kind of delving into those details, right? So if
Yes,
you,
same with the
Mhm.
person who says there's no landlord after Friday and our building needs repairs. Call your local legal
Yeah,
aid immediately. Um,
that's that's terrifying.
yeah. I actually don't know if there's penalties for somebody who violates VAWA. That would be a question for Heather, and I'm sorry, I can't answer that one. And I don't know the ins and outs of how housing support interacts with HUD COC supportive housing, because you're right, generally COC supportive housing does provide rental assistance. So the statute does say that housing support can be payable to HUD COC supportive housing for the long-term homeless. But I don't know like what's primary.
Mhm.
And I think finally, this one I think might be from a landlord. There's a tenant who has lots of lease violations. Can they simply non-renew due to their violations? It depends on whether one of these programs is involved.
Mhm. Need to have just cause for most of them, but lease violations could potentially fall into that depending on what it is.
Yep.
All right. I thank you so much for all of that um, marathon of information. Ben, you're a delight, and I really appreciate your expertise in all of this. Again, folks, if you've got questions that are specific to your situation or that maybe weren't covered here, feel free to reach out to either legal aid or to Homeline, and we will do our best to help you and get those questions answered. So thanks, everybody, and have a wonderful rest of your day. And we'll see you next month. Bye.